Minor advocate Mr. R.K. Verma has to
Whoever may be, he has to be
clarification, and he is in courtroom number
Let him
13.
be. Anybody else for the petitioner here?
Sir,
You are the ones who are relying on Chaya judgment. So today nobody is interested. We'll close it then.
Where is Mr. Dinesh Singh Chauhan?
He is online.
Your
Connected online.
Yes, explain.
My lord.
You uploaded.
My
this
lord.
judgment. You uploaded this judgment. Explain it.
My lord, I have uploaded this judgment, and lordship, there is only one clarification, that is the exam guideline is notification or not, and lordship not lordship, because annexure P1 lordship, may appreciate the lordship, this is only exam guideline, my lord, and that is totally depend on the rules 2018 that are not amended in the respect of 12.4 clause lordship. Annexure P1, my lord.
You just explain para 32 of the judgment, because rules are silent on that point.
My lord.
Come to para 32 of the judgment.
Recruitment notification.
Before the judgment lordship, I brought to some more important fact, lordship.
Mr. Chauhan,
Very
Mr.
important,
Chauhan,
very important.
we have not listed it for a fresh hearing. This is a
No,
clarification we are
only
seeking.
clarification. My
Clarification,
lord.
please clarify the purport of paragraph 32 of the judgment that you have uploaded.
Your Lordship, if I may submit. Your Lordship, in para 32, Your Lordship, the Honorable...
We are asking Mr. Chauhan, you don't want to argue, let him argue.
Your Lordship, I may also submit if I may be given
Lordship,
the
we are
opportunity.
there.
Yes, Mr. Chauhan.
Yes, sir.
Your lordship, 32, married lordship again. छाया जजमेंट में 32 रीड करो, my lord, इसमें.
Yes.
Para 32 of the judgment.
The appellants who admittedly are more meritorious than the last selected candidate under the general category cannot be excluded from the consideration under the general category in the absence of any express provision in the recruitment rules oblique notification.
Yes. Now tell us.
The relax.
So this is this not a recruitment notification?
No, lordship. This is an exam conducting guidelines only, lordship. Only exam conducting guidelines. उसके ऊपर भी लिखा हुआ है.
Where is the exam notification?
Annexure P1 है, lordship.
P1.
P1 of the writ petition.
So if that is the notification,
That is not notification. उसमें लिखा
then
है.
we are asked, Mr. Chauhan, we are asking you, which is the notification for the examination?
That is annexure, my lord, P3. That is a notification.
P3 are the rules of 2018.
Yes, lordship.
We are wanting to know which is the notification for this examination.
They have introduced now to annexure P1. That is impugned.
Mr. Chauhan, you are the petitioner.
Yes, lordship.
Please tell us which is the examination notification.
Examination notification P1, my lord.
P1.
That is impugned.
P1
Yes, my lord.
12.4, read 12.4.
12.4, my lord. Your lordship. 12.4 at page number 25. ऐसे अभ्यर्थी जिनके द्वारा पात्रता परीक्षा में 90 से कम अंक प्राप्त कर आरक्षित प्रवर्ग में अर्हता अर्जित की है, उनकी अभ्यर्थता चयन परीक्षा के लिए आरक्षित प्रवर्ग में ही मान्य होगी. ऐसे अभ्यर्थी अनारक्षित प्रवर्ग में चयन हेतु पात्र नहीं होंगे. अनारक्षित प्रवर्ग सिर्फ चयन हेतु उन्हीं अभ्यर्थियों के संबंध विचार किया जाएगा जिनके द्वारा पात्रता परीक्षा 60% अथवा अधिक 90 अंक प्राप्त कर अर्हता अर्जित की, साथ ही चयन परीक्षा में 50% अथवा अधिक अंक प्राप्त किए हों.
Now, if this is the exam notification, please now reread para 32 of the judgment and explain it in your, how do you look at it?
My lord, the para 32, the Chaya judgment is dealing the meritorious candidate, my lord. And my petition is that challenging the 12.4 clause, lordship. My case is to declare that is ultra virus or not, because there is no NCT clause.
Mr. Chauhan, if we do not hold that 12.4 is ultra virus, then in terms of 32, it applies against you. That's your argument?
Yes, my lord, my argument is exactly, my lord, because if that is not declared ultra virus, because I have loaded NCT clause 2024, my lord, at reference section, my lord may appreciate 8 NCT Gazette 2014, and the division bench of this court has clearly says any rules the framed by state that should not be against and that should be accordingly to the NCT. I have uploaded the judgment
Mr.
at
Chauhan,
number 9.
please don't re-argue the matter. All those submissions you've already made, we only wanted this clarification.
Lordship, my senior is yes, Lordship.
Can I just, my lord, only limited clarification, my lord.
Yes.
Now, my lord, Lordships, my lord, rightly pointed out that paragraph, my lord, in that judgment.
You see, para 32 says, in the absence of any rule or notification. So notification is P1, P1 is, there is a stipulation
Yes.
that it is excluded.
Now-
One is you are challenging P1 on the ground of it being ultra-virus. Assuming we were to uphold it,
Yes.
will it still be covered by para 32?
My lord, if the rule book is treated to be a rule or a notification as is contemplated under law, what I would submit is, my lord, a rule would be a rule which is notified as per 309 of the Constitution.
No, you see,
Now,
11,
these are a set of instructions.
Rule 11, 4 and 5
Yes.
say for the eligibility for the selection examination, conditions etc. will be notified. This is the notification.
Lord, the word may be a rule or a notification,
Yes.
but this is a set of instructions, and your lordships would also.
So we are
not-
wanting to know if this is not the instructions in notification, which is the notification for this examination?
That is the statutory rule, my lord, P3 at 32.
Mr. Nagrath,
Lordship would also.
Mr. Nagrath, if it was in 2018 rules, there was no debate. It is not in the 2018 rules. We are just testing the para 32 which has been uploaded, we are examining this case in light of para 32. 32 says rule stroke exam notification.
That is 309 Constitution rule, my lord.
Rule
Not the
stroke-
set of instructions issued for.
No, Mr. Nagrath,
My lord.
we are not that the notification is amending the rules.
Our submission, I'm sorry.
Our query is different.
Yes.
You see, judgment says unless it is provided by rules or notification. It is not provided by the rules.
No.
Now, examination notification, if P1 is examination notification, then why is it not covered by para 32? If it is not examination
For two
notification,
reasons.
which is the notification?
For two reasons, my lord.
Yes.
The P1 is a rule book set of instructions not to be treated to be rule or notification which is as per law, my lord, required to be.
Which is the notification for the exam?
Notification or rule is only P3, my lord, rules, and lordship would.
Then there is
consider-
no exam.
My lord,
You see, there is a rule, then there is a notification issued that so and so exam is to be held.
my lord,
Which is that notification for this selection?
assuming for the sake, my lord, that yes, rule book can be called as a notification. Now,
Employment
12.4.
Complete word used by the Supreme Court is employment notification. Recruitment
Assuming
rules,
for the sake
recruitment
of.
rules, no
assuming-
doubt 2018 rules or employment notification.
Now, assuming, my lord, I am taking that forward. Assuming that employment notification is the notification which in that para is relevant, which says rule/notification. Now, 12.4 is totally contrary to the statutory rule. That submission your lordship would consider because the rule does not prohibit.
Mr. Nagrath, we are considering that, we are not discounting that at the moment.
My lord, if I
When we
succeed
are-
on that
you see,
ground,
After the judgment was reserved.
Yes, I can see
This
that.
Chhaya was uploaded.
yes.
Now
I-
Chhaya
I'm
case, para 32 says rule stroke notification. So the issue is this a examination notification? If we hold it to be ultra-virus, situation is different. If we uphold it, yes, it is intra-virus and they had the power to issue it, then will it not be covered by 32?
I
para 32?
would reply to it like this, my lord. A notification in normal parlance would be, my lord, a set of rule book issued.
What
for
is the
purpose.
employment notification?
My lord, the notification for this examination is certainly
P1.
no dispute, but,
Then we'll consider.
my lord, the core submission.
No, that argument is still there.
My
We
lord,
are not-
if I
we are-
succeed,
Mr. Nagrath, we are not discounting the earlier arguments. You've already argued
Yes.
P1 is contrary to P3. has
yes,
to be-
if I succeed on that count, on two counts, my lord,
If
that
you succeed on that, there's no dispute.
then everything
If you
goes.
don't succeed on that, then in terms of para 32 of Chaya judgment, this plays the whole the field then. That's the point.
My lord, even
MP general clauses act में sir notification means a notification published. It has to be published somewhere. It cannot be. MP general clauses act में.
okay, sorry.
Has the result been declared?
Yes,
Result is declared. So how many are,
Could get through.
how many, this is OBC, no? This is OBC.
No one is successful.
OPCW all.
No, there are.
No one is successful.
How many?
Any petitioner is successful.
Your
No,
Lordship,
none of
they
them.
have scored in the selection test. They have scored more marks, but in TET because of that.
You see, your argument is that none of us have made it, but if some meritorious
Migrated.
who have secured their migrated to general category,
Then
we
we-
will come up. That's
then
your
we-
argument. How many are there in the OBC category who will qualify? Because then we want to know how many petitioners are there.
Sir, we have already appended, Your Lordship,
We want the number.
Give the figure now, give the figure. How many would migrate?
How many would migrate?
Making room for those numbers.
Because the issue would be that supposing 10 migrate,
The 10 would be pushed up.
10 would pushed up.
Yes.
10 will go down. From the general category, 10 will,
Yes.
those 10 will be necessary parties.
If migration is a law, then being pushed
Yes,
out.
Mr. Nagra, then they
Yes.
will be, today, if there is a list published, they are in the selected
Yes,
list.
they may be required to be heard, my lord. I am not saying that they may not.
That is one.
May not.
Secondly, how many of you are in first 10?
That figure my friend will give.
Your Lordship, because
You
we
have any
individually
figures somewhere?
we have individually filed the petition. So in my petition, we are 19 petitioners and 12 are qualified. So there are more than, Your Lordship, that list was prepared
All
and
right,
283 people with.
12, none of the
9.
select list candidates are here. That right? So 12 in the select list will migrate?
Yes, they will.
Your calculation shows that? Now, will the seniority be affected by their migration? Their seniority? Apparently not, because they'll still be in the merit list.
Your Lordship,
Seniority has
that will actually result because the result was on the percentile basis, Your Lordship. If migration is upheld, Your Lordship, because for each category, different percentile was given. For example, for general category, 17%, the cutoff was 17 percentile on the basis of how many people are there. So percentile system is different from percentage system, so
So
it will
12
require revision of the result and then a fresh merit list would be required if migration is upheld.
Let the respondent produce this.
Because
data, my
that
lord, so
list
your
has
lordship
already
may
been-
be able to
We also
decide.
want to know.
Yes.
How many of you are in top 12? If none of you are in top 12
Sir,
and the top 12 who would get the benefit are not here, why should we entertain this?
Your Lord,
If others above us are migrated,
Mr. Nagar.
then we will come up.
No, that is what we are asking. Firstly, there are two questions.
Yes, ma'am.
He's saying 12 people are entitled to migration.
Yes.
They're not before us, we're not concerned. Their seniority may or may not be affected, it's one issue. Because those 12 migrate, 12 general category will be excluded and 12 will come in
Yes.
from OBC.
Yes.
Those 12 who are excluded are necessary parties
In the open list.
in the
From
open, in the
yes.
general list.
Yes, they may be required.
And the 12 who are going to, who are the top 12 in the non-selected list from this category,
Who are to be migrated.
who are not to be migrated, who are to be now included.
Yes,
in
who will come up,
216.
my lord. Yes.
Are they here? If you are say 100 in the list,
We are those. My lord, many of us are those, my lord, that category.
please tell us how many will migrate and how many of you are there. Rest will say go home.
Yes.
No purpose.
Yes, I can see.
If you are say 50 in the serial list, in the anticipation that none of the 40 will take
That
it.
requires a little calculation, my lord. How many would be securing above the open cutoff so as to migrate?
And
how
open
many?
will be made
Yes,
necessary.
exactly, those number would go out, my lord, excepting barring a situation where, my lord, some reserved category are there which would not be, my lord, because there is no migration. So the entire block will go down. And here, my lord, they will move up, that number of
You
candidates.
see,
my lord.
if there are 12, that last 12 general category even there may be some in between from other categories, they will not be affected.
Yes, they all would be pushed down, my
The
lord.
general will go down.
Yes,
That many number of general going down are necessary parties.
yes.
That many non-selected coming in, are they here?
We'll give the data.
That
Can we have it
detail will
tomorrow,
be
my lord? आप इसको data.
You also tell us.
Your Lordship,
We'll
if I
also,
may submit-
my lord,
if I may
compile that
submit,
data,
Your
my lord.
Lordship,
Sorry?
Your Lordship, in this scenario, Lordship, a cutoff percentile was given. The cutoff percentile was 17 percentile. Now, Your Lordship, there were hundreds and thousands who got 17 percentile in the general category. Now, Lordship, in OBC category, Your Lordship, because when it comes to percentile system, Your Lordship, it is based on the when the survey is done, it is based on the survey population. So the OBC percentile was as high as 80% or 85 percentile, Your Lordship. Now, Lordship, it is now because OBC category, they had scored more than 17
No,
percentile.
no,
Your
how do you
Lordship.
say OBC was 80 percentile? No,
Percentile,
how
Your
do you say OBC was 80 percentile?
Your Lordship, because percentile basis में था, तो then subjective percentile has been made.
So this is not a consolidated
No,
percentile?
it is not consolidated. It
Then
is
you
not
don't
based on
get anything.
percentage. It is not based
Then you
on
don't get anything at all.
No, Your Lordship,
If there is no comparative list, what he's saying is OBC list is separate and their general list is separate.
Your Lordship, they
And your
had given
percentile,
different
your
percentile.
percentile is given based on OBC list.
Your Lordship, they had set up different percentile for different categories. This is what
Then
my
Mr.
submission
Nagaraj,
is.
the entire argument has been well fallacious. The entire case has progressed on a wrong premise. OBCs were considered separately, general category were considered separately, separate percentile prepared.
Lordship, but there are,
No, my lord, there's some confusion in this submission, my lord. My friend will
Is
not
there
make
a-
a submission
is there
so
a
as
common
to
list
virtually
declared on
utilize the
the-
entire
Common
case.
list that was being made. Your Lordship, now because of this.
Where is the result? Show us the result.
Your Lordship, mine is.
Your Lordship, for
3.4.
rejoinder, under rejoinder of the main
Is there
submission.
a list published? Result list published?
That list also has been given by my. It
Which
has
matter
been,
is the- is the
attached with
list here in which matter?
5636.
It is there in first case with rejoinder.
Yes, my lord, get rejoinder and
RJ4,
yes, there is a cutoff list and result also.
RJ4.
It is started RJ4, Lordship. This is RJ4. The petitioner got secure, Lordship, the percentile 30.71.
Whether the
And the
result
selected
prepared,
person?
whether the result prepared on the common percentile or the percentile of each category was decided by different.
Each subject by Lordship, subject wise. There's a two types of teacher, guest teacher and non-guest teacher. And the subject wise, music teachers and middle school maths teacher, middle school English teacher. So subject wise. So I have filed a separate list according to my percentile, according to respect of my case
ये तो
Lordship.
इतने सारे हैं कि
Proper.
नंबर पे। ये देखो ना 43.81
और नृत्य के लिए कंबाइंड लिस्ट बनी है कि कैटेगरी डिफरेंट फॉर डिफरेंट फॉर ईच सब्जेक्ट बट देयर आर 5 lists SC ST open की कंबाइंड लिस्ट
सर ये बाद में सर ने डायरेक्ट
so here, the final score is separate and percentile is separate. But final score is given on the basis of the performance and selection test.
So there are separate lists for open SC ST other lists.
Yes.
We say, for example, OBC
कैटेगरी के 12 persons
in the OBC list.
उसके बाद जब कैटेगरी बदलती है मान लो ओबीसी कैसे फीमेल है
List have to be separate.
सर जैसे जो वाले का जो कटआउट है वो ये दिया और पेपर है फॉर एससी से तो उसको एससी वाली लिस्ट में डाल दिया और वो बन चला गया वो जनरल की लिस्ट में ओपन की लिस्ट में नंबर कैसे आता है ये तो इसमें का जो नंबर आ जाएगा लास्ट सिलेक्ट कैंडिडेट के परसेंटेज तो अपने देखो इसमें ज़्यादा है इसमें ज़्यादा है ये 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 ज़्यादा है तो अगर अपने 12
Respective lists. Pinky setting भी ये होता है.
यस
ठीक है, ये रिजल्ट से ओपन में जाएंगे तो दे विल मेक स्पेस फॉर न्यू पर्सन. दिस इज व्हाट that is we are virtually in the wait list of
All right, then we'll,
exam data.
anyways, we'll consider that aspect then. So learned counsel for the parties have given their clarification, judgment reserved.
Obey.
Use the mic, please. Is your mic on?
Well, it's as far as the contentions raised by the petitioner are
Mic
concerned.
कोई नहीं काम करता है. You see, there was a time when there were no mics in court and we could be heard.
Well, it's clause para 29 would be relevant, Millets, in the judgment.
Para
in
29 of the judgment.
Of Chaya's judgment, Millets.
Yes.
The facts of the case are typical, Millets. In this case, what happened, Millets? Initially, a notification of examination was, if I may read it, Millets. It is pertinent to note that MCSE issued a notification dated 31/1/2023 for conducting TAIT 2022 online examination between 22 to 23 to 3/3/23. The state government has not prescribed any prohibition with regard to migration of research reserved category candidates who have secured more marks than the general category candidates of the open category. However, the Commissioner, Government of Maharashtra, issued a communication on 25/2/2024, that is the day on which the merit list was to be published, referring a decision of this court in Pradeep Kumar and mentioning that the candidates from reserved category who had availed relaxation and TET have been considered eligible for selection under their respective categories. So, Millets, in this case, what happened, Millets, there was no notification.
Para 32.
Yes, Millets.
In the absence of any prohibition.
However, in this
What
case,
has been used
in this case,
in the absence of any express prohibition in the
Yes,
recruitment
ma'am.
rules of slash notification.
in this case, what has happened, in the notification, there is an express part.
But in the in the rules, there is no prohibition.
In the recruitment rules, there is no prohibition, but in
Can
the
it be brought
notification.
about by,
Now the only question.
yes, can it be brought about by way of administrative orders? That's the issue.
That's the issue,
That's the
core
issue.
issue is that, and
That's the issue.
admittedly, 2018 does not contain.
Law doesn't prohibit
2000
migration.
2018, there is no prohibition.
Yes. And it has been done till now, madam.
P1, the examination notification brings it in, and you are saying that this is contrary to the.
Yes, this is administrative instructions termed as notification, but not the notification which under the General Clauses Act is required to be notified in the official gazette. Even that it is not so. The two words are rule or notification. The rule would be 309. Notification under the Clauses Act, would be something which is notified by the government in the official gazette.
Which will be the recruitment notification.
The word is notification.
Annexure P1 would be. Annexure
Simply the
P1
use
would
of
be the-
word notification.
Employment notification.
Yes, ma'am.
In this judgment, if you will see para 19, then the word is employment notification.
I'll reply, my lord. Just as the word, my lord, rule book, my lord, just as the word rule book doesn't make it a rule under 309, it's a set of instructions at the end of the day, nothing more.
All right.
Your Lordship, if I may submit, there are certain case laws, Your Lordship, on this
No more case
aspect.
laws, we
Your
just wanted
Lordship,
clarification.
only on this
Chaya.
clarification.
You had your opportunity
Your
when you
Lordship,
had.
not on that TET point, Your Lordship, only on this point, Your Lordship, regarding regarding statutory rules, Your Lordship, because the statutory rules are silent on this aspect, Your Lordship.
You've already argued
Prohibition.
that.
Your Lordship, I have brought.
We are
only
not
one
going to
case.
reopen either then we'll delist the case
Your
and that's
Lordship,
the end of it.
These.
We'll de-reserve the case and
Your
let
Lordship,
it
then
come up
this
in
may
due
be
course.
taken, Your Lordship, only.
We
this
are
is-
not taking anything new.
Your Lordship, only it is a clarification
All
regarding
right,
the
take
point
down.
32.
Learned counsel for the
Okay,
petitioners.
Your Lordship, I
Let
have
it
not
be.
submitted.
My friend
No,
was
you see, you
handing over
want to
judgment.
reopen it, we'll reopen it. Why should we reserve it? We'll de-reserve the matter and list it as and when.
Yes, Your Lordship.
Chaliye.
Serial number 4, along with 85 connected cases.
Oblige, Lords.